Right now, somewhere in the world, a visa applicant is sitting in a consulate waiting room, nervous, prepared, documents in order, ready to answer every question the officer asks. And they have no idea that the officer already knows about the post they made on Facebook 3 years ago, the TikTok video they thought was funny, the tweet where they complained about wanting to stay in America forever, the comment thread where they vented about working under the table. They walk into that interview thinking the hard part is answering questions out loud. They don't realize the interview started the moment they filled out their application and handed over their social media handles. And by the time they're sitting across from that officer, a picture has already been painted. The question is whether the picture matches the person. This is not speculation. This is the operating reality of U.S. visa processing in 2026. And if you are applying for any visa, any green card, any entry into the United States, or if you are a permanent resident crossing back through a port of entry, what you have posted online is now part of your immigration record in a way it has never been before. While social media is full of noise about this topic, we are looking at the official text, the State Department guidance, the DS-160 and DS-260 application requirements, CBP enforcement authority, and the specific grounds of inadmissibility under the Immigration and Nationality Act that officers are using to deny applications based on digital footprints. Remember, I am an analyst guiding you through the system, but this is educational content, not legal advice. Always consult a qualified immigration attorney for your specific situation before your interview or your next entry into the United States. Let's start with the foundation, because a lot of people don't fully understand what they agreed to when they started their visa application. When you fill out the DS-160, which is the non-immigrant visa application, or the DS-260, which is the immigrant visa application, there is a section that asks for your social media identifiers. Specifically, the application asks for your usernames and handles across a list of platforms that includes Facebook, Instagram, X, formerly Twitter, TikTok, YouTube, LinkedIn, and others. This is not optional. This is not a field you can skip or leave blank unless you genuinely have no presence on any of those platforms. Providing false information on that form, including claiming you have no accounts when you do, is a misrepresentation. And misrepresentation under INA Section 212 is a ground of inadmissibility that can follow you for life. So, the first mistake people make is thinking they can just not mention an account. Maybe they have an old Twitter account they forgot about. Maybe they have a second Instagram under a different name. Officers are trained and equipped to search for these. They are not relying solely on what you tell them. The handles you provide are a starting point, not the finish line. But this is where it gets complicated, and most applicants have no idea this is happening. The vetting doesn't stop at your handle. Consular officers and Department of Homeland Security personnel have access to tools and databases that allow them to search for accounts associated with your name, your email address, your phone number, and your biographical data. If you have a private account, that limits some of what they can see, but it does not make the account invisible. The existence of the account matters. What they can observe about it matters. And any publicly accessible content, even on an otherwise private account, is fair territory. CBP officers at ports of entry have authority that goes even further. Under existing law, CBP can request access to your phone and your accounts at the border. They can ask you to unlock your device. Refusing is your right, but refusal can and does result in extended secondary inspection, missed flights, and in some cases, denial of entry. We are not in a world where your digital life stays separate from your immigration life. Those two things have merged. Now let's talk about what they are actually looking for, because this is the heart of what you need to understand. There are specific categories of social media content that trigger red flags under INA Section 212 grounds of inadmissibility. The first and most common is anything that suggests immigrant intent on a non-immigrant visa. If you are applying for a tourist visa, a student visa, or a work visa that requires you to maintain non-immigrant intent, and your social media shows posts about wanting to stay in America permanently, about planning to find a way to remain after your visa expires, about how you're going to figure out how to never go back home, that content directly contradicts what you are certifying on your application. Officers are trained to identify this disconnect, and it is one of the cleanest grounds for a visa denial under INA 214B. The second category is evidence of unauthorized work. This one is particularly dangerous because people post about it constantly without thinking. A post celebrating a paycheck from a job they weren't authorized to hold. A photo at a work site with a caption about the grind. A Facebook update about the side business they're running in the United States on a tourist visa. Any of these can be used as evidence that you have previously violated the terms of a visa or that you intend to do so again. And once that finding is made, it doesn't just affect your current application. It can affect every application you make going forward. Stay with me, because the next category is the one that is resulting in some of the most severe consequences we are seeing in 2026. The third category is political extremism and national security concerns. This includes content that expresses support for designated terrorist organizations, content that promotes or glorifies violence, and content that is deemed to reflect ideological positions incompatible with U.S. entry under INA 212A.3. This is not a narrow category. Consular officers have broad discretion here, and the threshold for flagging content in this category has been lowered significantly in the current enforcement environment. A post that you thought was a joke, a meme you shared without much thought, a comment you made in a heated political discussion years ago, these things are being surfaced and reviewed. Let's look at the facts, not the fear. The vast majority of visa applicants are not posting extremist content, but the point here is not to alarm you unnecessarily. The point is to make you aware that the standard for what draws scrutiny is broader than you might expect, and that your social media history is being read by someone who does not know you, has no context for your personality or your humor, and is making a decision in a matter of minutes based on what they see. Now, here's the part that people most frequently get wrong when they hear about social media vetting, and it is the fatal mistake referenced in today's title. They think the solution is to delete everything before the interview, clean up the accounts, remove the posts, make the profile look pristine. And this instinct, while understandable, is not only ineffective, it is actively dangerous. Deleting posts or deactivating accounts in the weeks or days before a visa interview is a pattern that investigators recognize. Officers are trained to look for it. They note when accounts that were previously active suddenly go dark. They look at account creation dates and deletion timestamps when those are available. They use archived data, including content captured by third-party archiving tools, the Wayback Machine, and other digital forensics resources. A post you deleted in 2024 may still exist in a cached or archived form that is accessible to someone with the right tools and authority. And beyond the forensics issue, there is the misrepresentation issue. If you delete content that contradicts what you have stated on your application, and an officer discovers that content existed, you are no longer just dealing with a problematic post. You are dealing with a finding of willful misrepresentation. That is a significantly more serious legal problem than the original content would have been. Take the example of a student from Brazil applying to extend her F1 status while preparing for graduate school in the United States. Years earlier, she had posted on her personal Facebook page about how she planned to find a job after graduation and stay in America as long as possible. She didn't think anything of it. It was a young person's excitement. Before her visa interview, a friend told her to clean up her social media. She deleted the post. The consular officer during the interview asked her directly about her post-graduation plans. She gave a carefully worded answer. The officer noted in the record that there was evidence of prior posts consistent with immigrant intent that appeared to have been recently removed. Her application was denied not just for the original intent issue, but for the appearance of an attempt to conceal it. That is not a worst-case scenario. That is a pattern being documented across multiple consulates right now. So what do you actually do? Here are 3 concrete steps you need to take before any visa interview, any green card application, or any international trip where you will be re-entering the United States. The first step is to conduct a full, honest audit of your social media presence before you fill out any application. Go through every platform. Review your posts, your comments, your likes on public content, and your tagged photos going back several years. You are not looking to delete things. You are looking to understand what picture your profile paints to a stranger with no context. If something concerns you, that is a conversation to have with an immigration attorney before you do anything with that content. The second step is to be completely accurate when you fill out the social media section of your application. List every account. If you're unsure whether a platform is listed, disclose it anyway. The risk of omission is far greater than the risk of disclosure. An attorney can help you understand how to address any content concerns through proper legal channels, including written explanations or supplementary documentation, rather than through deletion. The third step is to begin practicing what your social media presence says about your immigration intent going forward. This is not about silencing your voice or pretending to be someone you're not. It's about understanding that your social media is now a legal document in the eyes of U.S. immigration authorities. What you post today may be reviewed at your next interview, your naturalization application, or your next re-entry. Build that awareness into how you engage online. The digital footprint and the immigration file are no longer separate things. They are one record, and that record is being read by people who have the authority to open or close the door to your future in the United States. Immigration policies and enforcement practices shift fast, and 2026 is proving that the scrutiny is only intensifying, not easing. The people who stay protected are the ones who stay informed, who understand the system as it actually operates rather than how they wish it worked, and who make decisions based on verified information rather than rumors or last-minute panic. Subscribe to Immigration Path USA so that when the next enforcement shift happens, and it will happen, you hear about it here first, broken down clearly, calmly, and with the kind of detail that actually protects you. Share this video with someone in your community who is preparing for a visa interview or a green card application right now. Because the mistake we talked about today is completely avoidable, but only if people know about it before they make it.